Be ready. 5 seconds. Start. Section 3 of the Tariff Act is a charging section. Section 3, subsection 6 makes the provisions of the Customs Act applicable. This would bring into play the provisions of Section 15 of the Customs Act, which inter alia provides that the rate of duty which will be payable would be on the day when the goods are removed from the bonded warehouse. That apart, this court has held in C Customs Act that in the case of duty of customs, the taxable event is the import of goods within the customs barriers. In other words, the taxable event occurs when the customs barrier is crossed. In the case of goods which are in the warehouse, the customs barriers would be crossed when they are sought to be taken out of the customs and brought to the mass of goods in the country. Admittedly, this was done after 4th October 1978, as on that day when the goods were so removed, additional duty of excise under the said ordinance was payable on goods manufactured. We are unable to accept the contention of that what has to be seen is whether additional duty of excise was payable at the time when the goods landed in India, or as he strenuously contended they had crossed into the territorial waters, import being complete when the goods entered the territorial waters is the contention which has already been rejected by this court in Union of India versus Apar Private Limited, decided on 22nd July 1999. The import would be completed only when the goods are to cross the customs barriers, and that is the time when the import duty has to be paid, and that is what has been termed by this court in C Customs case as being the taxable event. The taxable event, therefore, being the day of crossing of customs barrier and not on the date when the goods had landed in India or had entered the territorial waters, we find that the additional duty of excise was leviable, and therefore additional duty under section 3 of the Tariff Act was rightly demanded from the appellants. A priori for a sale of purchase to qualify as a sale or purchase in course of import, the essential conditions are that such sale shall occur before the goods had crossed the customs frontiers of India, and the import of the goods must be effected by such sale or purchase. Arguably, for sale or purchase of goods to be regarded as sale or purchase in course of export, section 5(1) of the CST Act provides for the following conditions. 1. The sale or purchase shall occasion such export, or 2nd, the sale or purchase shall be effected by a transfer of documents of title to the goods after the goods have crossed the customs frontiers of India. A constitution bench of this court in Muhammad Sirajuddin and others versus State of Odisha has held that expression in the course implies not only a period of time during which the movement is in progress but postulates a connected relation. The relevant portion of the judgment is extracted as a sale in the course of export predicates a connection between the sale and export. No single test can be laid as decisive for determining that question. Each case must depend upon its facts, but it does not mean that distinction between transactions which may be called sales for export and sales in the course of export is not real. Where the sale is effected by the seller and the seller is not connected with the export which actually takes place, it is a sale for export. Where the export is the result of sale, the export being inextricably linked up with sale so that the bond cannot be dissociated without a breach of the obligations arising by statute, contract, or mutual understanding between the parties arising from the nature of the transaction. The sale is in the course of export. In the Nilgiri plantations case, this court found that the sales by the appellants were intended to be complete without the export, and as such, it could not be said that the sales occasioned export. The sales were for export and not in the course of export. In the present case, it is not the case of the appellant that the goods in question were being exported, since the goods are to be consumed on the board of the foreign going ship and the same would be consumed before reaching a destination. It does not fall under the definition of export. The sale cannot qualify as a sale occasioning export unless the goods reach a destination which is a place outside India. Further, since the goods have been sold from the bonded warehouse and had crossed the customs port or land customs station prior to their sale, it cannot qualify as a sale in course of export within the meaning of section 5(1) read with section 2AB of the CST Act. Even declaration made under section 69